Excuse me. My name is Laurel Evans. I'm a program planning lawyer with the Law Society's Continuing Education Department, and I'd like to welcome you to this morning's program, Wrongful Dismissal Alternatives to Trial. I'd like to thank today's faculty, not all of whom are here at the moment, for taking the time to come to speak to you today and to prepare the materials that are in your binders. Excuse me. Sorry, I have to remind you that this is a non-smoking facility. If you'd like to smoke, you have to do so through the east doors through which you entered this morning. Just downstairs from there are the public telephones. There's 3 which are available for your use, and the men's washrooms are located there as well. The easiest way to find the ladies' room is to go through the brown doors that is at the main reception and to go downstairs from there. You can receive messages, which we would ask that you take a look at the message board, which is, we have a message board which is adjacent to our registration desk, and I ask that you check it at break because we quite often get panic-stricken messages from secretaries, and that's the only way that we have to convey messages to you. I'd like you to take a look at your binder of materials. We have an evaluation form in the binder, and I'd ask that you complete it on a timely basis as the day progresses. We take the evaluations seriously, and we rely upon them in producing our programs and for evaluating those that we have presented. I'd like to take a few minutes and introduce Barry Fisher, who is the chair of today's program. Barry is the creator of the Wrongful Dismissal Database. It's a computerized database of over 1,500 wrongful dismissal cases that's part of Search Law, the research arm of the Law Society of Upper Canada. His practice is dedicated to the area of employment and labor law. He has been involved in wrongful dismissal arbitrations both as an arbitrator and a lawyer. Barry is a member of the Ontario Management Labour Arbitrators Association. He's on the executive of the ADR section of the Canadian Bar Association, and he sits as a representative on the Users Committee of the ADR Centre, which is part of the Ontario Court General Division. I'd like to remind you that George Vassos has prepared a paper. He is going to be speaking towards the end of the day. His paper will be available for at the break. We're reproducing it for you. As well, when you registered this morning, there was a diskette that is a model arbitration agreement that was kindly prepared by Barry, and it should have been picked up by you when you registered. If you didn't get it, please ensure that you go back out to the registration desk and pick it up. I also ask, could the people that are on this side of the room please shift over to the middle? It makes it a little easier for the speakers when they're directing themselves to you. And as well, Marvin Gorodensky, who's our second speaker, has some slides, and I think it would be much easier for you to see them if you're seated in the center. That's sort of why we have the ropes there.
Good. I wondered about that.
Try to be a little subtle. Anyways, I'll now turn the program over to Barry Fisher.
Thank you very much, Laura. First of all, regarding the evaluations, you can just fill them out now and say excellent. It tends to speed things up. I just want to speak for a minute or two as to why I designed this program. Basically, it's because I hate trials. When I'm actually there, they're sort of fun. But the preparation for the trial and more or less the waiting for the trial has always been a great aggravation to me. So I was quite thrilled to start reading recent cases where the use of the summary judgment rule became actually useful, because it certainly wasn't for the first 5 or 6 years of its existence. And it got me thinking about all the different ways that we can resolve these matters without going to trial, because we all know that 95 to 99% of them don't go to trial. And usually the ones that do are exactly the ones that never should. So I put together this and tried to come up with all the types of topic headings that someone who does a fair number of these cases would be interested in doing. This program is headed to the intermediate level person, which means we assume you know what a wrongful dismissal is, which one's the plaintiff, which one's the defendant. We won't be explaining what just cause is and reasonable notice and that sort of stuff. So we hope that you at least are familiar and hopefully have done some, and then we'll get something out of this. The first panel is going to be on the use of the summary judgment rule in wrongful dismissal cases. Was it Rule 20? See, I even know the rule numbers. We have three distinguished speakers, starting with, on my left, we have Loretta Merritt from Torque and Mains, a partner at Torque and Mains who practices exclusively in the area of wrongful dismissal. And she's my personal favorite because she quoted my wrongful dismissal database in a case that got quoted. So that just proved her merits and to me of Ms. Merritt. That's only the first of many bad jokes you will hear this morning. We then have Regional Senior Justice Archie Campbell, who is a well-respected judge, not only for his intellectual merit, but I think one of the first judges to use a laptop computer in court. So not only is he computer literate, which to me means a lot, he's also quite experienced in the whole area of wrongful dismissal, and specifically has delivered papers, I believe, on summary judgment to other judges, so we get to hear what he's actually told his brother and sister judges. And last, but certainly not least, we have Richard Nailberg of Goodman, Phillips, and Weinberg, who is going to be giving us the employer approach to summary judgment, which is always interesting because that's probably the person who's going to be most reluctant to go summary judgment. So I'll be interested to hear what Richard's employer viewpoint is as to why employers also can welcome summary judgment applications. And we're going to start with Loretta.
Thanks, Barry. From the plaintiff's perspective, it's a good idea to consider a motion for summary judgment right from the outset. Whether it be on the whole or part of the claim, this is something you ought to be considering when you act for a plaintiff from the moment they walk through the door. The advantages are obvious. It's a quick and less expensive resolution. It's important to realize that in a wrongful dismissal case, the cost of trial is often disproportionate to the ultimate recovery once you take into consideration payments already made by the defendant, unemployment insurance overpayments which have to be repaid, deductions for taxes and CPP and UI, and then any income earned in mitigation. By the time you're done deducting all of those amounts, the ultimate recovery can be relatively small compared to the significant costs of a trial. And so for a plaintiff who's out of work and therefore highly motivated to have the case resolved early, a summary judgment can be a very attractive alternative. It also avoids the somewhat unpleasant experience for most plaintiffs of giving evidence in open court at a trial. Although they may be cross-examined, it's a little different for most people to be cross-examined in an examiner's office than it is to have to sit in a court and go through the trial process, which can be intimidating for most people who aren't sophisticated. These people, wrongfully dismissed plaintiffs, are in a very different position than your typical commercial litigation client, financially, sophistication-wise, etc. And so this alternative can be very attractive. But it's important for you to realize that you must have an extremely strong case to succeed on a motion for summary judgment. The test of no genuine issue for trial is an extremely high threshold. And if the statement of defense raises triable factual issues, then you must turn to the documentary evidence. It's possible that the documents could show that the defendant's position is untenable. If the issue is a purely legal one, the facts are agreed and the only issue is reasonable notice, that may be a good case for summary judgment. It's important as plaintiff's counsel to advise your clients of the risks of bringing these motions. If you lose, then you will likely be, or could well be, or your client could well, I should say, liable for 2 sets of solicitor and client costs. And that's quite significant. Sometimes as a plaintiff you can get lucky on these kind of motions. The defendant doesn't respond very well or doesn't respond completely in the affidavits, or the defendant is a very unreliable witness at the cross-examination. But if as counsel, when you see the defendant's materials, you can identify what could be a genuine issue for trial, it may be better at that point to cut your losses, serve a notice of abandonment, and you'll be stuck only with the defendant's party and party costs of preparing materials. The risk of proceeding with the motion is one I think the client must understand and must knowingly accept. It's not only your decision as counsel whether to proceed with such a motion. I think the client has to be actively involved and make an informed choice. With respect to the plaintiff's materials, the first thing is you must have affidavit evidence. You cannot rely on the allegations in the statement of claim. That's clear. And the plaintiff's own affidavit is preferable. The rule provides that you can use affidavit evidence on information and belief, but there will be an adverse inference drawn unless you can explain why it is someone other than the plaintiff giving this evidence. So 99% of the cases, you're going to want to put in the plaintiff's own affidavit on a motion for summary judgment. And I think in drafting the affidavit, the goal is to establish only those facts which are absolutely necessary to win the case. That way, you can, to some extent, narrow the risk of the defendant raising contentious issues. Once you've prepared and served the plaintiff's materials, then you have to obviously wait for the defendant's materials, and once you have those, you have a choice to make again at that point. Do you abandon and run? If there are not genuine issues raised in the pleadings, do you then proceed with the motion? Or 3, do you choose to cross-examine? My general rule is I don't cross-examine unless I have to, because of course that gives the defendant a chance to raise genuine issues that maybe didn't already appear on the pleadings. But if there is a genuine issue on the pleadings, then you either have to cross-examine or abandon. You can't proceed with the motion in the face of a genuine issue raised. As a matter of practice, I often get a second opinion. I'm somewhat concerned when I know the plaintiff and I know the case and I'm committed to it, that I may lack the objectivity really needed to assess whether there is a genuine issue for trial. I may already have in my mind visions of how I will eliminate that issue at trial, and that can to some extent weigh in your judgment. So I think it's not a bad idea to give to somebody else the materials, one of your colleagues or friends, and say, do you see a genuine issue for trial? Is that something that is beyond a motion for summary judgment? I think that's a fairly good idea. In the paper, what I basically do in the materials is outline the provisions of Rule 20 and a number of the cases decided under that rule. There's one interesting case that I'd like to point out to you, and that's Rosannon and Rosemount Industries. That's a 1994 decision of the Ontario Court of Appeal, and in that case, the court held that issue estoppel applies in cases where there has been a decision of the Employment Standards Branch. Very interesting little decision there. The Employment Standards Branch could make all sorts of determinations in the course of making a decision as to entitlements under the Employment Standards Act that could be used as a basis for issue estoppel and as part and parcel of a summary judgment motion. For example, Employment Standards Officer may determine that there was a constructive dismissal, or there was or wasn't a quit, or that an employee refused a reasonable offer of alternative employment or didn't. I caution you that the standard for cause is different. In a wrongful dismissal action, of course, it's just cause. Under the Employment Standards Act, it's willful employment misconduct. So you could have a situation where an officer says there's no willful misconduct, yet there is still just cause. So issue estoppel wouldn't apply on that, but there may be another of other types of rulings that are made in the course of an Employment Standards Officer's decision that could apply. I don't see any reason why the same wouldn't apply for appeals to the UI umpire and decisions of other statutory bodies as well. So that's an interesting thing to think about. It used to be that as counsel we tended to ignore those little employment standards hearings because there wasn't a lot at stake and sent the plaintiffs off on their own. But with the issue estoppel now clearly applying, it's a wise idea to do that. Before I conclude, I just want to take 1 minute, I think that's all I have left, and say a couple of words about Rule 21, which is the alternative rule. Rule 20 is summary judgment. Rule 21 is the motion for determination of a legal issue. And it sets out on its face where there's a question of law that will dispose of part or all of the action, you can use it, where there's no reasonable cause of action, where the court lacks jurisdiction. that sort of thing. I think this rule is particularly useful where there is a very good relationship between counsel. No evidence is admissible unless you agree, but if you can agree on a statement of facts, this can be a very useful way of going to court and getting one of the big issues, such as the entitlement to notice, resolved, even though you may not have all the other issues resolved. For example, there may be small issues about mitigation or entitlement to payments or that sort of thing, but you know, as counsel, if you get the big issue, the notice period resolved, you'll be able to negotiate and give and take on all the other small issues. And that's a particularly useful rule where there's a good relationship and there's an honest desire on both parties to have the case settled quickly, and all they really need is a word from the court, some guidance as to what the starting point is for the negotiation of the final resolution. I had one case where we did that, and then we ended up at the ADR Center and spent a half a day, hammered out all the other minor issues, which, had I brought a motion for summary judgment, clearly could have been opposed on the basis that there were genuine issues for trial. If the other side wanted to prevent me from succeeding, that could have happened. But the other rule was used, and that way we were able to negotiate that. As well, of course, there's another way to resolve these cases without trial, and that's by default under Rule 19. And in the paper, I make some comments. Generally, the rule applies the same in wrongful dismissal cases as it does in any others. I think that's probably my time, but we'll save a lot of time for questions.
Thank you. I've always found the default rule to be most invigorating. You get a wonderful judgment, and the worst thing in the world is not to have the employer file a defense, because you can rest assured he's not there when you go to collect. But it's an easy thing to obtain and absolutely impossible to collect on. Richard, tell us about the employer's perspective.
Well, the employer, I'd like to talk about two aspects of the employer's perspective. The first one being whether the employer should bring the summary judgment motion, and the second being how the employer should respond to a summary judgment motion brought by the employee. Now, the employer who has a strong case reviews the statement of claim that it gets from the employee and sees that there's really nothing in it. It's a frivolous case, and has to decide whether to file a defense and wait it out in the normal course, or file its defense and then bring a motion for summary judgment. Now, what it really takes from the employer's point of view is an immediate addressing of the issues in the statement of claim. If you file a pro forma statement of defense and not really give thought to the issues raised there and the evidence that's available from the employer, then you can't really judge whether you would be successful on a motion for summary judgment. So what the counsel should do is review the statement of claim immediately with the employer and marshal any evidence that the employer has with respect to the issues there. Now, if you have a moderate case, there might be you're confident that you'd be successful, but you're not sure whether there'd be genuine issues for trial, then it may not be appropriate for the employer to bring a summary judgment motion. And that's because it costs money to bring the motion. You have to prepare your evidence, you have to hold cross-examinations, you have to have a hearing, and all that comes with an upfront cost. And if you're not successful, if the employer is not successful with that motion, then the cost will be borne by the employer, possibly on a solicitor and client basis, of the examination that he conducts and the costs of the the responding employee. Often, the employee, as Loretta said, is the one who's in more dire financial straits. The employee wants to bring the thing on quickly because the employee's been fired or whatever and needs the money. The employer typically isn't in that position, and it may be more cost-effective to just wait out the employee and not bring the motion for summary judgment. If the employer doesn't bring the summary judgment motion, but just files a defense, a strong defense, it's possible that the employee will give up, will not pursue the case, and money will be saved by not doing it. That being said, the employer still might have the desire to get rid of the claim, get it off the books, and if they have a very strong case, then it's probably a good idea to do. Another thing to keep in mind is if you have an employee who is somewhat reluctant to proceed, by bringing a summary judgment motion, you force the issue. Suddenly there's an exchange of affidavits, there's cross-examinations, and there's full disclosure in the litigation. Suddenly the employee who didn't think he or she had a very good case may change his position. So if the summary judgment motion isn't successful, what you've accomplished is given the employee an opportunity to see all the evidence at no cost to the employee at all, because if the summary judgment motion isn't successful, the employer will be responsible for the costs. So in fact, a discovery is held, or a quasi-discovery is held at the expense of the employer. So when advising an employer whether to bring a summary judgment motion, I think you should keep in mind that unless you have a very strong case, it may be most cost-effective to the employer not to bring the motion and simply wait and see what happens. If the employee does press on and discoveries go on, it may be appropriate to bring a summary judgment motion after discovery sometime before trial to avoid the cost of the trial. From the other point of view, from the employer responding to a summary judgment motion, it's even more crucial to review the evidence that your client has right from the beginning, because you may review the statement of claim and find that the employee is gearing up for a summary judgment motion, a crisp statement of claim with not a lot of extraneous issues that would require a trial, such as punitive damages or the manner in which the employee was terminated. If it's simply the employee had this term of employment and was terminated on this day and got this much notice, then it's likely you're going to be facing a possible summary judgment. So what you have to do with your client as an employer's counsel is immediately review the evidence and put forward in your defense all of the issues that will bear on the termination and notice period. This isn't to say you make up issues, but you marshal all the evidence that you can find to make sure that everything is before the court in the statement of defense and in your responding affidavit when it comes. And as Loretta said, it's very important to focus not on the legal conclusions, such as what the notice period should be, or whether the employee or the alleged employee is in fact an employee or perhaps some kind of contractor. You have to get at the factual issues, because that's what the court's going to look at on a motion for summary judgment. If your defense and your responding material simply says, I think the notice period was fine, or this person wasn't an employee, it was an independent contractor, that's going to get you nowhere, because what the court's going to look at is what are the facts underlying the employment. What experience did the employee have? How old is the employee? What were the circumstances of the termination? When was the notice given? Was it oral or written? These factors will go into the calculation of reasonable notice. Similarly, for an independent contractor, if the employer wants to say, no, this person was for hire, there was an employment contract, there was no intention of having an employment relationship, then don't just plead the conclusion and refer to the conclusion in the affidavit. You must say, this person came to work between 9 and 12 every day. He had his own employees, etc. It's the facts that are important, and the facts that will get you to avoid the summary judgment. Another thing that a responding employer might do is serve a jury notice. Now, maybe Mr. Justice Campbell can address this later, but there is a case where a jury notice was served and a summary judgment was granted anyway, and I'm not sure what the courts are doing with that. If you have a right to an adjudication by a jury, what happens when these factual issues go before a judge? And just to complete, at cross-examination, if you're a responding party, you've got to find genuine issues in dispute. If the material from the plaintiff is poor, maybe you want to restrict your questions, as Loretta said. But if the material is very good and you've got a problem on summary judgment, then you should ask broader type questions to get out behind the apparent lack of disputes, get to some disputes, get the witness to contradict himself or herself, and you can use this evidence at the motion to avoid judgment. The paper that's in your materials that I've done is more of a practical guide to drafting the affidavits, the kind of issues that you might want to raise in your affidavit material, both from a plaintiff's and from a defendant's point of view. I think that's all I can say now.
Thank you, Richard. That's the first time I've heard an employer suggest the tactic of issuing a jury notice to get rid of a summary judgment application. As a I'm always wary of juries, and you never know whether you're going to get 12 people who've just been fired and are seeking their vengeance, or 12 self-employed businessmen who think that a week for every decade of service is perfectly reasonable, and why is the plaintiff asking for more? I don't have the trust in the common man that the California jurors do. I much prefer a judge. Now, talking about judges, how's that for a roll-in, eh? Mr. Justice Archie Campbell is going to tell us the view from the bench, as they always say.
Start off by saying I always know there's something wrong when I end up agreeing with both counsel, but I agree with both counsel for the employer and counsel for the employee. Let me deal with one issue very quickly first. That's a question of the jury notice. If you go to Mr. Nailberg's paper at page 3, there's a reference there to a case called Hutchison and St. Leonard Society. It was a worker in a halfway house who was fired for taking part in some pretty disgusting locker room type sexual harassment. One of the plaintiff's arguments when the defendant halfway house brought a summary judgment motion to dismiss his claim was that he said he served a jury notice. He had a substantive right to have the matter determined by a jury. The judge in that case, I think it was Madam Justice Lynn Leach from London, said, well, that's true. You've got a right to a jury if there's a serious issue to be tried, if there's a genuine issue for trial. But the only argument the plaintiff admitted taking part in this activity, which prima facie entitled the halfway house to fire him. His defense was that, well, lots of other people were doing it as well. That was no defense. Therefore, it wasn't a triable issue. Because it wasn't a triable issue, there was no right to a jury, because you don't have a right to have a jury try non-triable issues. So I don't think it makes much difference whether there's a jury notice there or not. If it's a triable issue or a genuine issue for trial, it goes on and you get the jury subject to having the notice struck out. If it's not a genuine issue for trial, then it doesn't matter. Getting to the main points, I think that most judges nowadays would encourage motions for summary judgment in wrongful dismissal cases if you can keep it simple. If you can keep from cluttering it up with issues like defamation and punitive damages or aggravated damages from the plaintiff's point of view, if you can keep it from being cluttered up with issues of just cause from the employer's point of view, if you can keep it simple, I think it's clear that most judges now would encourage the use of such motions. It saves money for the clients, it saves court time in the face of pretty heavy caseloads, and it's just a better way to do things more quickly and cheaply for the public. There's a quote in Ms. Merritt's paper, just make a note at page 14, from what Chief Justice Morgan said in Cronk, and he encouraged the use of summary judgment where the issue really was what's reasonable notice. There's also a very important judgment by Mr. Justice Lane called Luz, L-U-Z. It's in Ms. Merritt's paper, I think at page 6, where the plaintiff was smart enough to drop the mental distress issue, drop the aggravated and punitive damages. They went right on the question of reasonable notice. Justice Lane said, given the relatively modest amount asked for, it's desirable to resolve the issue if possible without the expense and delay of trial. You'll find a lot of earlier cases, 90, 91, 92, where judges were reluctant to grant summary judgment in wrongful dismissal cases if there was some factor that might make it more of a borderline case. I think nowadays you're getting more and more judges prepared to do it, and the proof of that is in what Chief Justice Morgan said in Cronk, what Mr. Justice Lane said in Luz. I think it's still true what Mr. Nailberg says in his paper at page 4, that in a borderline case, judges prefer to put it on for trial. But generally speaking, the bottom line, I think, is what Ms. Merritt says in her paper at page 19, and that is, it appears from the above cases, courts will not determine the proper period of notice on summary judgment if there's some factor complicating the issue. The recent cases, however, demonstrate an increased willingness of courts to grant a motion for summary judgment where the only issue is a proper period of notice. So I agree with both of them. If it's borderline, You're not going to get it. If you can keep it simple, the general trend is to try to dispose of it on summary judgment. And judges welcome it when lawyers for plaintiffs can convince their clients to take punitive damages and defamation and injured feelings off the table, go to court on the simple, clear issue of notice, which is usually the only live issue. I think judges welcome it when counsel for employers can convince the employer to take an issue of cause off the table that may or may not be viable. It's going to cost as much to fight it as it is to give a reasonable notice period, depending on the amount of money involved. These are cases in which the judges have a relatively easy job. I think probably the hardest job in these cases is for the plaintiff and the defendant, for counsel for the plaintiff and defendant, to convince their clients that there's going to be more money in their pockets and their lives will be less cluttered if they forget about punitive damages, defamation, and cause, go on a motion for summary judgment on the notice period only. So generally, I'd encourage it, and I think most judges encourage it if you can keep it simple.
Thank you very much. We're now going to open up the area to questions, and I have some questions that I'm going to ask. I'm going to start off, but I'm going to switch back and forth between the crowd and the questions I thought up. I think clearly what's come through here is that the legal principle of KISS has applied. Keep it simple, stupid. And leave your exotic cow claims and your exotic cow defenses for seminars like this, but not if you want to bring a summary judgment application and actually get your client some money quickly. Plaintiffs always appreciate getting money before they lose their house, as opposed to 2 years later. One of the reasons I've never done one of these summary judgment applications, which is one of the reasons I organized this seminar, so I could find out how to do it properly. And one of the things I've always wondered about is how I don't like doing affidavits. If I liked that, I would have been a family law lawyer. So I've always been concerned that I'd have to spend endless hours preparing affidavits, and if I was going to do that, I might as well have a trial. So what I want to ask the two counsel at this stage is what information should go into a plaintiff's affidavit and a defendant's affidavit, and let's construct a relatively easy hypothetical of your basic 45-year-old product manager, 12 years service, base salary, some sort of commission, and there's some benefits floating around there, and it's an economic restructuring. Couldn't be too much simpler. Loretta, what would you put in that affidavit?
In that kind of a case, you need a introductory paragraph that basically establishes that the plaintiff's an employee, that he's employed pursuant to a contract of an indefinite duration, and that his employment has been terminated, specifying no notice. And to support those allegations, you can put in an employment contract or a letter of hire or the termination letter as exhibits if you have them. In terms of determining the reasonable period of notice, you have to address the factors in Bardell and the Globe and Mail, and those are the age. Hopefully that's not in dispute. I guess you could put a birth certificate as an exhibit if anybody disputed the plaintiff's age. I've not seen that yet. Length of service, again, often you just need to say the start date was and the end date, but if there are gaps, you should go into a little bit more detail. Why the gap? What was the reason for the gap? After in the second period of employment, did the employer acknowledge service from the first? Often the way they do that is in vacation entitlement. They'll give the person vacation entitlement based on the entire period of employment. That's pretty much an admission that it should all be considered in determining reasonable notice. So you put in the length of service. You put in some evidence about the character of employment, the terms of employment. Of course, if there's a job description or something like that, it's good. You want to put in the salary level. There you can use pay slips or T4 slips or any letters increasing salary or anything like that. Again, the more of the defendant's documents that they cannot dispute, the better. You may want to go into the character of employment in terms of supervisory function, but again, you've got to be careful. A plaintiff may have a unrealistic view of the character of their employment. They may think they were more managerial or more supervisory than in fact the defendant is prepared to admit. But if they had 8 people they supervised, you can put that in the affidavit materials. If they attended management meetings, you can put that in the materials. Again, what you want to do is limit yourself to things that the defendant cannot and will not dispute. Then you want to go into the availability of similar employment having regard to experience, training, qualifications. Again, you can put it in a resume, but make sure it's not puffed up. You got to go through the client and make sure, is there no way they can dispute any of these facts? If the industry is narrow and specialized, if the geographic location is remote, these are things that may not be contentious. But again, limit it to things you really think the defendant will not dispute. And then there are a whole bunch of other weird and wonderful factors, which are referred to in almost any CLE materials or wrongful dismissal text. And Barry wrote an article called "Is Notice Still a Factor in Wrongful Dismissal Cases" in the CCELs, where he goes through all of the other factors that people have, or that courts have considered, or people have presented in wrongful dismissal cases to increase or decrease the notice period. And then finally, you want to put in the affidavit something about mitigation. Although the onus is on the defendant to show that the plaintiff didn't take reasonable steps to mitigate, if that's the position, the plaintiff should put in not only the actual mitigation, I got a job on X date earning this, and here's my new pay slip or my new employment contract, but I think it's not a bad idea to put in some of the mitigation efforts as well. And then you'll have to see what comes from the defendant. Obviously, often the defendant has nothing on the reasonableness of mitigation, and you're not concerned. You just have to deduct the actual amount. If the defendant has no factual basis, I think the court is going to be on an increasingly willing to just dismiss that part of the allegation in the defense. So basically, that's what you want in the plaintiff's affidavit. Again, you want to limit yourselves to things they can't argue with.
Okay, Richard, you get Loretta's affidavit. On the front cover, he's got a picture of his family and his 4 kids, 3 of them which are suffering from disabilities and go to special schools and all that stuff. How do you respond in a warm and kindly manner to this affidavit?
Well, again, it depends on the facts. I agree with Loretta. You don't want to probably won't dispute the age or the term of employment or the experience of the individual, but you want to attack things that there will be a chance to get at, like the notice of termination. I'm sure the plaintiff will have said that the termination came at a later time, and the employer will, of course, want to move that termination date back. So what you want to look for are letters in the file, in the employment file, where you advise the employee that you would be terminating him, and attach that to your defendant's affidavit. If there are no written records of the termination date, you'd want to make some allegations of the oral termination, if there was one. To back that up, you'd have the person who spoke to the employee testify or swear to what the conversation was. You might have other people present swear affidavits, tell what the conversation was. You might attach internal corporate memos that show an intention to terminate the employee at a particular date. If there's a restructuring, then maybe details of when that restructuring was known to occur and when the staff was informed. Maybe it was informed earlier than the plaintiff has suggested. Maybe this individual plaintiff had some unique problems that he didn't swear to, like maybe he was terminated for cause, maybe he was incompetent and warning letters were given. You should attach performance reviews if they're relevant, if comments were recorded of conversations during the performance reviews, things of that nature. Anything that will show that either the termination date was prior, or that the person was terminated for cause, or that there's a reasonable issue of either of these things, reasonable factual dispute. I think that's all.
Can I just add that I think if you look at the papers, that there's an excellent summary of what should be in the affidavits at pages 12 to 19 of Mr. Nailberg's paper for the plaintiff and 19 to 30 of his paper for the defendant. There's another thing to be very careful of, and that is the best foot forward principle that's mentioned in both papers. If there's somebody on your side that has potentially crucial information and you don't put forward some evidence from that person, you're very likely to have an adverse inference drawn against you. There's a number of cases cited in both cases, but remember always the best foot forward principle. You don't put your best foot forward, you're going to get hammered. And if there's somebody whose evidence could be considered to be crucial, you've either got to put it forward or put forward some evidence as to why you can't find that person or why you're not adducing their evidence?
The question of Mr. Justice Campbell, I used to mark papers in college, and I'm sure I marked them in a similar fashion to most professors, that to some degree you apply the weight test, that if it's too thin, they think the person hasn't done a good job, and if it's too weighty, it's like, gee, there must be a serious issue for trial here. Can you give us a thumbnail sketch, so to speak, of how long, how short is too short for plaintiff's affidavit and how long is too long? First of all, how much time do you have? Are you getting this thing that morning, or have you received it the night before? Is this 14 motions on that day you're listening to?
Well, the trouble with the court system the way it is, the material could have been filed 2 weeks before, and it's probably been lost in the court office, and you get it later on that afternoon. Don't flood the court with too much material. Always remember that if you're the moving party, what you want to show is that it's such a clear-cut case that there's no genuine issue for trial. And to some extent, if you're the moving party and you put forward too much stuff, the judge might say, gosh, this looks like a pretty complicated case. I don't know if this is a simple enough thing to resolve by summary judgment. So the moving party wants to keep it simple, and the responding party wants to convince the judge that it's such a complicated mess that it should go on to trial. Unless the responding party is smart enough to do what was recommended in these cases like Liz and Kronk and say, yeah, let's keep it simple and just go on the notice period. The other thing is that when you talk about weight, never forget what was said in Ungerman by Associate Chief Justice Morden. I think it's quoted in Ms. Merritt's paper at page 5, that the court's function on these motions is not to resolve an issue of fact, but to determine whether a genuine issue of fact exists. So if I've got one piece of advice, if the plaintiff and the defendant can get together and say, look, let's save everybody some money, let's resolve this on a summary judgment motion, you can both keep it simple. If you can't reach that sort of a sensible agreement, and one party's determined to drag it out to trial and cause great expense to their client, then the moving party wants to keep it simple, and the responding party wants to make it look complicated. But I'd urge you all to get together, keep it simple, and save your clients a lot of money.
Any questions from the floor? Yes.
At a seminar here last spring, we were talking about the decision that was then and the issue came up for summary judgment, and the 3 justices were asked how they felt about summary judgment in your assessment situation. And 2 of them were sort of theoretically supportive of summary judgment, but both expressed some reticence at not being able to take a look at the plaintiff to assess them when they're deciding upon the notice period. Now, we can sit around and talk about how that shouldn't matter, but we know it does. And what their comments have stuck with me. I mean, I'm always on the lookout for one of these cases to take, but their comments have stuck with me because I'm always wondering what I'm losing by my client not being able to look the judge in the eye and garner whatever sympathy there is to be garnered for the situation. And I appreciate your comments from the entire panel on sort of that perspective on whether summary judgment.
I think that's a good point, and that is a factor you can take into account. Contrary to popular belief, most judges are human beings, and take into account
Some exceptions.
Some exceptions, and present company, I'm not sure accepted. No, present company is a human being. I'll just leave it at that. If you've got a really sympathetic plaintiff, yeah, you're going to lose that. And I find over the years, I've often been shocked by how judges have liked my clients when some of the times after 2 years with them, I can't stand them anymore. But when you only know them for 2 hours, they seem to be wonderful people. And it can be the reverse, too. If you have actually a horrid little plaintiff that you would prefer to hide in the closet somewhere, summary judgment may be a great idea. And the employers is different. It's harder to find a sympathetic employer. On the other hand, if you have sort of a, what's that case? The one where the employer gets to plead poverty. I can't remember the name of it off the top of my head. Bohemia. And so your defendant client is some little businessman who's put his entire life savings into his company, and his wife works there, and his kid and all that. You may want to dispel the thought that this is a huge corporation that can afford this, so you want that employer to testify. But if you're some huge megalopolis, you may not want that to come forward. I think that's a valid factor. Anybody else?
Well, I mean, it cuts both ways for both the plaintiff and the defendant for the reasons just indicated. If your plaintiff's very sympathetic, you may think that you're going to get more if you go on for trial and get the benefit of whatever sympathy the plaintiff's going to engender with the judge. On the other hand, as somebody said, if the plaintiff appears to be sort of a lazy, non-industrious malingerer, hey, it cuts the other way. I don't think it's all that important. I mean, if you're talking a lot of money, it may be worth your while, but it costs so much more to go on for trial. We'll come to that issue later on. I just repeat again and again what's at page 14 of Ms. Merritt's paper, where Associate Chief Justice Morden really encourages it, and what was said by Mr. Justice Lane and Liz. You're going to save your client in the long run, I think, a lot of money if you can go this way.
Remember, Ms. Kronk never walked into the courtroom, and one judge thought she should get 22 months, and 3 of them thought she should only get 12. So who knows what happened if someone had actually met her. Any other questions from the floor? Ms. Rubin?
It may be that the motion might not necessarily be heard by the judge who's been case managing it, because the case management motions don't always get heard by the same judge. So I don't think it makes a lot of difference whether it's in case management or not.
Yes, over here.
I guess like a lot of us are still trying to come to grips with the Court of Appeals reasons in Cronk. One of the things I believe that Justice Weiler talks about is the summary judgment and the liability of it. And I guess in terms of this genuine issue for trial test, if I'm reading Cronk correctly, and please correct me if I'm wrong on this, my understanding of that test was we were dealing with substantive evidence. But she seems to say in there, if I'm reading it correctly, that if you're going to do what the plaintiff's counsel did in Cronk and try to sort of break a tangent, go out on a tangent, or ask the motions judge to be progressive, whatever way you want to look at it, in terms of the direction the law should take. In other words, if there's an issue of law there, in this case obviously being what is the individual's particular job circumstances, what bearing should that have on the notice period. If you're going to do that, then a summary motion is not the place to do it. So it seems to cast doubt on if you're ever going to go in there with sort of a gutsy kind of a presentation and say, I think, Your Honor, you should be going, and taking this law and moving with it here. But that's, that you've got to wait for trial to do that, because trial is a place to bring in all the factors and let all the parties hash that out.
2 comments on that. First of all, that wasn't the plaintiff's idea. The plaintiff in that case did not come up with the idea that clerical employees should, God forbid, get what vice presidents get. That was Mr. Justice McPherson's own idea. The parties did not raise that issue, and that's one of the big things the Court of Appeal talked about. But I agree with you. Summary judgment should be for the no-brainers, for the, Your Honor, this is easy, just follow the rules. If you want to carve new elements out of the law of wrongful dismissal, I think you should head for trial, because you'll need something, if it's new and innovative, something's got to be a triable issue there. And so I think to a large degree, the Cronk case was determined by the desire of Mr. Justice McPherson to make an important statement, and I believe his first written decision ever.
I mean, the other thing is, take a look at the evolution of the willingness of judges to grant summary judgment. They're more and more willing to grant it, and the fact that Madam Justice Water was in dissent may tell you something about which way the evolution is going. And when you get Associate Chief Justice Morden saying in such strong terms, that quotation there, I think that tells you something as well. So you never know. A lot depends on the judge. First rule for counsel is to know your judge. And but it seems to me that the evolution is going more towards the majority than towards the dissent.
Yeah, the trend, just if I can add it, it's very different, 92, 93, as opposed to 94, 95. So it's, I mean, there seems to be a real switch. In the 92, 93 decisions, there's more reluctance. In the 94, 95 decisions, the courts are increasingly willing to grant the motion. So I think there really is a movement in this area. And there's, you know, a lot of nice statements. There's at least 5 cases in my paper from the 94, 95 period when judges have said, yes, we're not only we're going to do it, but this is a good thing to do. So I think you may be able to distinguish Cronk on that basis. And as you pointed out, if you're going to attack what was sort of a pretty solid basis that character of employment generally meant less notice, you're going to deviate from that, whether it was proper for the judge to do it on his own or the parties. The point I think Madam Justice Weiler was making was, if you're going to attack the factual underpinning of a proposition that's long established, then maybe we do have to call some evidence and have a trial on that. But if you're just arguing about, you know, the factors, the traditional Globe and Mail factors, you stand a better chance.
Any other questions from the floor? All right, I have one more for the panel here. One of the advantages of summary judgment application is you get to court quickly and hopefully before the end of the notice period. And there seems to be different ways of dealing with how do you award prospective damages. British Columbia has a long history of summary judgment applications. Their rules either seem to be more liberal or their lawyers are more courageous. And they routinely do award prospective damages. And in British Columbia, they deal with it in a number of different ways. Some of the cases actually award salary continuation. They make an award for future periodic payments. Some of them award a lump sum and then come up with some sort of mythical discount in the unlikely event that this plaintiff would ever find a job, and they take 5 or 10% off. Ontario seems to have developed a somewhat different technique. I think it was in a number of cases, and I never remember the name, so, where they actually awarded the plaintiff the quantum of the future damages in some sort of trust arrangement that they have to pay it back if they end up getting a job. And I was just wondering what the panel's comments on with what you saw the future and what they thought the most practical way of dealing with that issue of future damages. Loretta, maybe you can start.
Yeah, I can't help but think that if you don't take into account mitigation, there's going to be a smaller notice period. I mean, I just can't imagine a really long notice period where you're bringing a motion at the beginning of it and no obligation to mitigate. I mean, it's a really unfair result for the defendant in most cases. And there certainly is a legal basis, as Barry said, in other jurisdictions, but here in Ontario as well, in the personal injury context, after the introduction of no-fault benefits and a substantial increase in no-fault benefits, which have to be deducted from the damages in the third-party liability case, the court has developed what's called a Cox and Carter order. And what it says is, we'll make the defendant at trial pay everything, and then any income the plaintiff receives from their no-fault benefits in the future is held in trust and handed over automatically to the defendant. So there is a basis there. And as well in Cronk itself, the court talked about the fact that the obligation to mitigate continues during the notice period, even if that extends beyond the date of judgment, and talks about the plaintiff remaining accountable for income earned in mitigation. I can see a case to be made where the plaintiff perhaps is impecunious or doesn't have sufficient assets to satisfy a judgment, persuading the court that rather than do that and have the defendant perhaps have a hollow judgment for monies back when the plaintiff mitigated, a periodic payment schedule be ordered. I think that's certainly possible and a smarter way to do it than trying to attach a contingency. I've always had a problem with general contingencies. For contingencies of life in the nature of 5 or 10% are easy, but when you start doing specific contingencies, will this person get a job? That becomes really difficult.
It's summed up pretty well at page 19 of Mr. Nailberg's paper. You got a bunch of options: deductions for contingent income, future return to court for damage reduction, constructive trust. Note in Cronk, in the Court of Appeal judgment, Mr. Justice Lackers here confirmed doing it on the basis of an obligation to account. But the more you think of it, the more you think that periodic payments is perhaps an easier way to do it, require periodic payments, and then just say that, on production by the plaintiff, the defendant, of some proof that there's no income during that period. It may be hard to enforce, but it seems more attractive than something, it may be more attractive than future return to court for damage reduction or trying to guess. And Mr. Nailberg shows at page 19 some of the problems when you try to make guesstimates for contingencies.
I think another advantage of this periodic payment scheme is that you could, I presume, the judge could order the medical and group benefits to continue during the same notice period, which is something that you wouldn't have the power to do if you simply awarded a monetary amount. And traditionally, Ontario courts, not traditionally, Ontario Court of Appeal has adopted the principle that you value benefits as to the cost of the employer. Well, the cost of an employer to provide dental benefits is probably about $35 or $65 a month. Those benefits are irreplaceable by a dismissed employee. And we have not adopted the rule in Ontario of replacement costs. We look at employer costs. So it's much better from a plaintiff's point of view and very cost effective from an employer's point of view to simply continue the benefits. And it would strike me that if asked, a judge may be able to order continuation of benefits on the same basis as salary. One last question then at the back.
Sure, if the plaintiff has enough money to wait, that's not a problem. The difficulty I have, especially in this economy, is I usually have a person sitting on the other side of the desk saying, if I don't get money next week, I can't make my mortgage payment. So that may provide some difficulty. But for a plaintiff who can afford that, certainly, especially where the mitigation issue is only how much did you actually earn during that period, and you can do that calculation and do the deductions, that certainly is something I think that could happen on a reference.
Okay.
Can I just very quickly on a reference, and I just talking to Mr. Nailberg briefly, the problem with the references is down the line it's going to cost you more money, you got to get more material together, how are you going to get an appointment with a master? It's just another thing you got to gear up for. It sounds like a fairly expensive and complicated thing to put down the line.
I'd like to thank the panel.
Just before you thank I hate to interrupt, but you gotta, Mr. Fisher's too modest to mention this, but if you look at page 24 of Ms. Merritt's paper, there's a reference to a case here called Slater and Reebok that refers to the benefits of a wrongful dismissal database that Mr. Fisher's put together. So I just couldn't let the panel go because he's so modest without referring you to page 24 of that paper. There's a judgment there, Reebok or Slater and Reebok of Mr. Justice Rosenberg, that does show you how helpful it can be. Say you get an employer, you say somebody aged between 50 and 60, service 20 to 30 years, upper management. You get a page and a half of various notice periods like that. I just bring that to your attention because of Mr. Fisher's undue modesty.
I have to say I agree with that. That database is useful not only for settling cases, but I put it right in the case book on motions and or trial. It's the one reliable, objective source the court has, as opposed to the polar opposite positions presented by counsel. And I think it's the way to go. And also, sometimes you can just agree with the other side. If that's the real issue in dispute, let's run the search, and then we'll settle it up based on that. And I'm finding that works.
And since it's being raised by somebody else, it's very easy to do. You pick up your phone, you call the Law Society, the search law facility of Law Society, you give the person the age, the position, years of service, whether the company is a big company or a small company. The Law Society works with you to determine the parameters of the search. If the person's 52, how far do you want to search on each side of that, their position. And for a mere $150 plus GST, within 24 hours you get a computer report that you can then staple in your motion book, and that may or may not put the issue of notice to rest. In the Slater case, I was pleased to hear that not only did the judge refer to it, he actually, as I understood, targeted and awarded what the statistical average of the database was. And following that case, I amended the database form so that you actually get the statistical average. Knowing the mathematical ability of most lawyers, I decided that it was useful.
And judges.
To have judges to have the computer do it. I remember once summing up a 3-day case, and I kept on referring to my client as a 7-year employee, and the other side finally stood up and said, "He was only there 6 years. Why does Fisher keep on saying 7?" I said, "Your Honor, he's right, and this is simply reconfirm my career choice of law over accounting." And on that note, I'd like to thank the panel, and we'll move on right away to Small Claims Court. Thank you. The next topic is small claims court and the employment law practice. And this is done to dispel the image that small claims court is the little sister or little brother of the wrongful dismissal world. There's an increasing number, the jurisdiction is now 6,000, right? 6. To those people who no longer have real estate practices and personal injury practices and family law practices, this is if it's done correctly, and Marvin's going to tell us all about how to do it correctly. I think that small claims court can be a moneymaker for lawyers and, of course, increase access to justice for clients and all that good stuff. And Marvin is going to tell us about it. And the reason I chose Marvin is because he zapped me on a couple cases using the small claims court. And after I told my employer clients how erratic small claims court judges would be and how sympathetic they were, the mere threat of a small claims court trial brought my client to their knees. So Marvin, he's going to tell us how to do that in an effective manner.
I would if this machine would be working, but it's not.
Oh, well, maybe it requires a mechanical assistance. I can operate Windows 95, but probably not with these things. Let me see if there's... Okay, I'm going to have to do it manually.
I've been asked to speak on small claims court as an alternative to general division trial. The first comment I have is, yes, small claims court is a trial process, although substantially less expensive, less formal, and more expeditious than Ontario Court General Division trial. As such, the small claims court is obviously a more desirable option than the Ontario Court General Division. As a result of the extremely low monetary jurisdiction of the small claims court prior to April of 1993, the small claims court was then used in the context of obtaining damages for wrongful dismissal only for lower level employees or for nuisance value. With the increase of the monetary jurisdiction of the small claims court from $3,000 to $6,000 on April 1st of 1993, the small claims court has become a more appropriate alternative to general division in substantially more circumstances, and is therefore no longer limited to lower level employees. Take the example that I show up here of a 40-year-old credit manager who's earning $36,000 after 4 years of employment and is terminated because of a reorganization. In that case, the employee is offered 4 weeks, or the minimums under the Employment Standards Act, Section 57 provisions, and let's assume that reasonable notice would be 3 to 5 months. In this hypothetical, could you turn the... In this hypothetical, on the left-hand side will be a small claims court. The right-hand side will be general division. What I suggest you would do in that scenario would be to proceed to small claims court and seek an additional 2 months or $6,000, which would bring the total, when added to the 4 weeks termination pay already received, of 2.92 months. The benefit of that is that the 2.92 months is basically within the range of reasonableness, but you have limited legal fees, and you're probably a trial within the year. The other option, general division, is a maximum of 5 months, in my opinion, or $15,000 less the 4 weeks received, or a total of $12,000 if you ultimately go to general division. You have substantially more legal fees and trial 2 to 4 years down the line. Under the circumstances, I would strongly suggest that you would much prefer in that scenario to be going to small claims court. The benefit of small claims court, though, as an alternative to general division trial, is most noticeable when small claims court is used in conjunction with statutory remedies. I have referred to several statutory remedies in my paper. The applicability of the Human Rights Code, Workers' Compensation Act, or Canada Labor Code should always be reviewed in assessing a client's options. In my opinion, a statutory remedy will almost always be a more desirable option than litigation. Since the Employment Standards Act applies to almost every employee in Ontario, I will concentrate on the relationship between the Employment Standards Act severance and termination pay provisions and the small claims court as the most desirable option to general division trial. In my opinion, the first exercise when meeting with one's client is to determine the employee's common law entitlement and as well the employee's statutory entitlements. The most common statutory entitlement is that of termination and/or severance pay under the Employment Standards Act. It is strongly suggested that one be acquainted with these provisions and their exemptions. Termination pay is Section 57 of the Employment Standards Act and are payable in amounts of 1 to 8 weeks depending on years of service. Severance pay is payable where the employee is employed for more than 5 years and the employer's payroll is more than $2.5 million. And is payable in amounts of between 5 and 26 weeks or parts thereof, depending on years of service. Termination pay and severance pay are payable forthwith upon termination and without execution of a release. In addition, severance and termination pay payments under the Act are not subject to mitigation. Therefore, termination and severance pay provisions may be used to secure part payment of wrongful dismissal damages. And they also may alleviate the terminated employee's immediate financial pressures. Keeping this in mind, counsel can seek employment standards minimums immediately, and thereafter seek additional entitlement for wrongful dismissal damages in small claims court. In this way, the maximum entitlement of an employee who chooses to proceed to small claims court after obtaining employment standards minimums is not the $6,000 jurisdiction of the small claims court, but $6,000 plus Employment Standards Act termination and severance pay entitlements. Mr. Fisher. One more. This is the hypothetical I had in my paper. Take, for example, a 45-year-old salesperson, let's assume the payroll of that company is more than $2.5 million, who was working for 12 years and earning $24,000 per year, and is terminated as a result of a reorganization. In this case, let's assume that the employer was offering 22 weeks in exchange for a full and final release, and in my opinion, reasonable notice under those circumstances would be 7 to 10 months. Mr. Fisher, please. In that scenario, you would have 3 options. The first option is to accept the offer of the 22 weeks or 5.08 months. And I just would like to make a note that the 22 weeks is just marginally greater than the minimums under the Employment Standards Act. The second option would be to refuse the offer, proceed to general division, where you'll have substantial costs and arguably a long time before you get to court unless you bring a motion for summary judgment. And the maximum award in that case would be around 10 months at the very best. The third option, and the most beneficial option, in my opinion, would be to seek employment standards minimums, which in this case would be 8 weeks termination pay and 12 weeks severance pay. So at that point, you'll have 4.62 months in your pocket, and then you proceed to small claims court where the monetary jurisdiction is $6,000, which at $2,000 per month would be an additional 3 months, for a total of 7.62 months, which is within the range of reasonableness. The benefit of the third option, and that is seeking employment standards minimums and then proceeding to small claims court, are even greater when one makes an argument that severance pay entitlements under the Employment Standards Act are not included in the calculation of common law damages. There is no doubt that termination pay under the Employment Standards Act is included in common law damages. The same is not true, however, of severance payments. In fact, there is conflict in the case law in this regard, and I have referred to several of these cases in my paper. The fact that this issue has not been determined by the Court of Appeal means that one could make the argument that the court ought not to take into consideration severance payments when calculating common law damages, which has the effect of leaving more of the $6,000 monetary jurisdiction of the court available for non-statutory payments. Take, for example, a 40-year-old laborer who's working for an employer with a payroll of more than $2.5 million, whose salary is $24,000 after 7 years and is terminated because of a permanent layoff, and is offered 14 weeks, which are the minimums under the Employment Standards Act, in exchange for a full and final release. The first option on the next slide, as indicated on the next slide, would be, the first option is to accept the offer of 14 weeks or 3.23 months. The second option would be to refuse the offer and proceed to general division. And of course, unless you're going to be bringing a motion for summary judgment, the cost and the time of proceeding to general division would not be worth it. The third option, and of course most beneficial in my opinion, would be to seek employment standards minimums of 7 weeks termination and 7 weeks severance pay, and then proceed to small claims court. Once you get to small claims court, you would argue that the court ought not to take into consideration, or the court ought to take into consideration only the 7 weeks received for termination pay, and not the 7 additional weeks received, the court ought to take into consideration only the 7 weeks received for termination pay, and not the 7 additional weeks received for severance pay when calculating common law damages. You would argue that the employee, therefore, would be entitled to an additional 3 months, or $6,000, which is a monetary jurisdiction of the court, which when added to the 7 weeks termination pay would total 4.62 months, which is within the range of reasonableness. But the beauty of this is that after you receive the 4.62 months, you still have another 7 weeks severance pay in your pocket, which would bring the total then to 4.62 months plus an additional 7 weeks, which would bring the total up to approximately 6.25 months. And you can see, therefore, that the benefit of not having the court include severance pay in its determination of common law damages is substantial. Whether you ultimately proceed to small claims court or general division, there are several procedural steps that I would recommend. The first is the letter of demand, in my opinion, should outline the client's position respecting the amount required to resolve the issue of wrongful dismissal. In addition, the letter should clearly indicate the amount required to satisfy statutory requirements should the employer be unwilling to resolve the issue of wrongful dismissal. In other words, tell the employer if he doesn't want to resolve the matter as a whole, that the employer has to pay the minimums under the Employment Standards Act. And this puts substantial pressure on the employer to deal with the issue short of the matter going, short of you issuing a statement of claim. And in my opinion, once the employer puts his or her hand into their pocket, they'll likely want to resolve all of the matters. Secondly, in the letter of reference, in the letter of demand, I would ask that you ask for a letter of reference immediately. Whether you're going to resolve the matter or not, I would always suggest that you ask for a letter of reference. And advise the employer that the failure to provide an accurate letter of reference may unduly lengthen the client's term of unemployment, and thereby increase the employer's liability for damages for wrongful dismissal. Alternatively, state that the failure to provide a letter of reference may lead to a claim for punitive damages. This again puts substantial pressure on the employer to provide the letter of reference and incidentally to make a decision whether cause will be alleged or relied on. In the event the letter is provided, then the employer all but concedes the issue of cause. Alternatively, if the employer fails to provide a reference, the former employee's damages may be increased, and this puts substantial pressure on the employer at that juncture. Thirdly, with respect to mitigation, always be certain that your client, or as certain as you can, that your client understands his or her obligation to mitigate. And that's from the first time you meet with your client. I would also suggest that you ask your client to keep a diary of his or her mitigation efforts right from the beginning. So when you go to discovery or you go to trial or you go to summary judgment, that mitigation doesn't need to be an issue, that nothing has to be left to memory. And you'd be surprised how often mitigation becomes an issue when it ought not, when the employee just forgets his obligation or didn't fully understand his or her obligation. So far, I've dealt with non-cause hypotheticals. In situations where cause is alleged, the use of employment standards in conjunction with small claims court is likewise a desirable option to general division alone. Take the example, which will be coming shortly, of a very soon, of a 45-year-old salesperson. This is the same hypothetical as in the paper. The only difference is that as opposed to the reason for termination being performance reorganization, let's assume that the employer is alleging cause. And of course, where cause is alleged, the employer is not offering anything upon termination. And let's assume if just cause cannot be proved, that the employee is entitled to approximately 7 to 10 months reasonable notice. In this scenario, the employee would have 3 options. The first option, as indicated in the next slide, would be to do nothing. In a situation where you do nothing and you're offered nothing, you get nothing. The second option is to sue in general division. Ultimately, and this is a cause scenario, you have to take out the fact that summary judgment is an issue. You can't bring a motion for summary judgment where you have allegations of cause. So you're going to have to go to general division, wait 3 or 4 years, where the issue of cause will be determined, and then if the court rules in your favor, the court will determine what the reasonable notice period is. The third option is to file employment standards claim. And you would seek 8 weeks termination pay under the Act and 12 weeks severance pay under the Act. And we're assuming that the payroll of this employer is more than $2.5 million. The test at employment standards is whether or not the employee is guilty of willful disobedience. In my opinion, if you're unsuccessful at employment standards, where the test is willful disobedience, you will also likely be unsuccessful if you proceed to general division or a small claims court. And the reason for this is essentially that the standard used in small claims court or general division is that of just cause. And in my opinion, just cause is a less onerous standard to prove than the standard employment standards of willful disobedience. In other words, in my opinion, willful disobedience will always amount to just cause, but not vice versa. If, on the other hand, there is no willful disobedience and the employer cannot prove willful disobedience at employment standards, then it'll give the employee substantial financial backing to proceed to the next level. It will also give the employee confidence to proceed to litigation. It will provide the employer a substantial incentive to settle all issues, given the fact that one statutory body has already determined that there has been no willful disobedience. And last but not least, it may provide the employee with the argument that the issue of cause has been determined and that issue estoppel would preclude the trial judge from determining the same issue again. And I referred to the case of Rasmussen and Rosemount Industries in my paper, and with a query as to whether or not just cause or the tests of just cause and willful disobedience are the same. In my opinion, they're not. There seems to be a small distinction between the two, which may ultimately preclude you from arguing issue estoppel. The next step would be to proceed to small claims court. As with any wrongful dismissal matter, by the time you get to small claims court, there are going to be a maximum of 3 issues to be determined. The first is whether or not just cause exists. The second is, if no just cause exists, what is the reasonable notice period? And thirdly, whether mitigation exists. Now, the rules of the small claims court are very similar to those of the rules of civil procedure. Although the small claims court process as a whole is substantially less formal than are the rules of small claims court. I just want to refer to some notable differences between the rules. And the first one I'd like to refer to is Rule 802, which states that a claim shall be served by the bailiff unless the plaintiff is represented by a solicitor, in which case there's only one "it may" in the rule. It may be served by the solicitor or someone acting on the solicitor's behalf. Now, this may not seem like a big difference, but given the fact that the bailiff normally takes 4 or 5 months in the Toronto area to serve the statement of claim upon the defendant, if you serve the claim yourself or have an agent do it, you'll get to trial 4 or 5 months sooner, which is a very large incentive and well worth the cost. The major distinction, however, between small claims court and general division rules is that discovery is not permitted in small claims court. There are exceptions to the general rule, but let us say that in 99% of the cases, wrongful dismissal cases in small claims court, you're not going to be entitled to discover the other side. What that means essentially is that discovery occurs at the trial itself, and the parties are not given the opportunity of learning the other side's case, good or bad, until you get to trial. And that isn't very conducive to settlement. Therefore, it's suggested that you make the opposing party aware of the good aspects of your case as they relate to the 2 remaining issues, I'm assuming mitigation and cause, by using Rule 19 of the rules of the small claims court. Rule 19 essentially says that a written statement or document described in Subrule 2 that has been served on all parties at least 14 days before the trial shall be received in evidence unless the court orders otherwise. As such, if mitigation is an issue, the next slide indicates which documents and statements are permitted to be served in accordance with Rule 19.02.1. And essentially, it refers to all documents and all statements. There are very few exceptions. So you could serve almost any document or any statement. So with the 2 remaining issues, hypothetically, that of, let's take the first one, mitigation. If mitigation is an issue, then what I suggest you do is serve your client's mitigation diary in accordance with Rule 19. Once the other side sees it, and the only issue is mitigation, well, that may prompt them to settle the case. Alternatively, If you do continue with a trial, it's going to limit the number of issues, and it's going to curtail the length of the trial. The next slide indicates, Mr. Fisher missed his cue the last time. No, one more. Where cause is alleged, then I would suggest that you serve the statements, relevant statements or documents in accordance with Rule 19. Now, relevant documents may include a record of employment that indicates there's no just cause, when in fact the employer is now alleging cause. It may be performance appraisals, commendations, whatever is in the file that shows that there is no just cause. Alternatively, any statements. By all means, serve them in accordance with Rule 19. It lets the trial judge take a look at these documents before he hears the parties, and it may also promote settlement, limit the number of issues, and of course shorten the trial. And Mr. Fisher indicated to me that my time is slowly coming to an end. All I can say is use the small claims court wherever possible. Use the small claims court in conjunction with employment standards whenever possible, and keep on putting pressure on the employer. Because without pressure, they will not resolve the case. And whether you have to go to small claims court trial or general division trial or summary judgment, always keep the pressure on. The alternative is trial 3 or 4 years down the line in general division, or in small claims court, it's a lot shorter. But you could always put pressure on them still when you're in small claims court.
Thank you very much. One other thing I think useful way you can use small claims court is in a mass termination, where you have a mass termination consisting of a lot of people that don't make a lot of money. These people like to sort of act in unison, and I would be concerned about bringing any sort of class action or something like that. But if you can get 5 or 6 or 10 or 12 people from the same employer laid off at the same time, it strikes me that small claims court is a perfect way to do it. You issue all the claims at the same time. You'll have your pretrial motions at the same time, your pretrial conference at the same time, and the trials at the same time, right? If you follow it all through. And you're doing 6 cases for really the expense of one, and that can be a cost-effective way too. Like the old days when they used to shovel out the personal injury cases. You can use small claims court for the same way for a plaintiff's practice. Thank you very much, Marvin.
Thank you.
And now's the coffee break. By George Vassos, and there's 2 pages that are being substituted in Deborah Sword's paper, so in other words, as we depart, please pick up the papers. We're now going to hear about statutory remedies, the 2 major ones under the Canada Labour Code, that obscure little thing that we hardly ever ignore, that we always ignore, and the Employment Standards Act. And in order to talk about the Canada Labour Code, we decided to bring in somebody from our fair capital, where they have more civil servants than you can shake a stick at and more federally regulated employees. So we have Janice Payne here from the firm of Nelligan Power to tell us all about the CLC and the ESA, as the code words are used. Janice?
Thanks, Barry. The Employment Standards Act and the Canada Labour Code continue to be really important to keep in mind in terms of looking at effective solutions for your clients. They used to be better in the sense that they both used to provide faster remedies. I can remember a time when if you had an Employment Standards Act situation, you could send your client down, and the same day the labor relations officer would be picking up the phone and calling the employer. Similarly, with Canada Labour Code, you could be pretty sure of being in front of an adjudicator in about 6 months. Those days are gone. They're certainly gone in Ottawa, and I imagine they're gone here too. Nevertheless, it's still a faster remedy, with the Employment Standards Act now having statutory severance pay. It's a more valuable remedy under the Employment Standards Act than it used to be, and practitioners in this area are, I think, continuing to pay more and more attention to these 2 pieces of legislation. The Canada Labour Code applies to employees employed in the public sector. It does not apply to mainstream public servants who have a whole host of legislation that looks after them. You're basically talking about people not in a bargaining unit, not mainstream public servants, working on a federal or in a federal undertaking, or Deborah will look at that in a minute in a bit more detail, perhaps working for Crown corporations. In Ottawa, we have to continually remind ourselves when we see a new client to check as to who the employer is and whether the employer might be caught by the code. But certainly in this part of the province too, it's something to remember all of the time. I'm going to probably spend more of my oral presentation talking about the code than I am the Employment Standards Act, because I'm assuming that that's something you may not be as familiar with and something that I've had a fair amount of experience on and might be able to assist you. Basically, it's available, as I've said, to employees involved in a federal business or undertaking. That's defined in Section 2 of the Code. Towards the back of my paper is a copy of Section 2. And if I can turn to that quickly now, just to give you a concrete sense of when this kicks in. Section 2 defines federal work, undertaking, or business and lists examples, included examples within that definition. Obviously, anybody engaged in navigation and shipping, railways, canals, telegraphs, ferries between provinces. Anybody operating a fleet of aircraft that crosses provincial boundaries will be caught by the Canada Labour Code. Radio broadcasting stations, banks, any work, and this hits us in Ottawa more than it perhaps does you people, any work or undertaking that is basically essentially federal in nature or for the benefit of more than one province. Anyway, the definition is there. It's helpful to keep it in the back of your mind when evaluating a new client. The remedies under the code include reinstatement, which is a little different than the Employment Standards Act, and can be very powerful, not just when your client wants reinstatement, but when the employer on the other side is going to be worried about it. So I always, when dealing with an individual client, encourage them to advance the claim, because I find it an effective bargaining tool, even if, as I say, the last thing the client wants to do is go back to work. Yeah, they sometimes have to be carefully coached on how to handle that question at the hearing if you get that far. The standard of what constitutes just cause under the Canada Labour Code is higher than at common law, and there is decision after decision that says so. It generally approaches the standards that you see in labor jurisprudence. So the employer typically has to show more in order to gain the sympathy of an adjudicator. It's another reason why it's important to keep it in mind. I have focused in my paper, because I was asked to do so, on the procedural aspects of exercising remedies under the code. One of the best texts on this subject is Grossman's text, Federal Employment Law in Canada, and I've mentioned it in my paper, and I recommend it to anybody dealing with a proceeding under the Canada Labour Code. In order to lay a complaint under the code, there are a number of qualifications an individual has to meet. They're listed on page 3 of my paper. First of all, the individual has to have completed 12 months of employment, no collective agreement in place, not a manager, and the dismissal must be disciplinary. If it's a dismissal due to lack of work, downsizing, economic reasons, there isn't a remedy under the Canada Labour Code. Now, the managerial exclusion, it's important to know, not to read this too much at face value. The adjudicators under the code have repeatedly said that it's only the most senior level of management that will be excluded from this remedy. If you've got a mid-level manager or junior manager, you can probably exercise the remedy under the code. And you should go forward with your complaint. Whether or not you should be there will be evaluated by the officer dealing with you right at the beginning. There are questionnaires that are used and completed both by the employee and the employer that try and evaluate the level of management, if you like, that attach to this particular individual's position. So it will generally be dealt with at that point, and you can have a pretty good sense that you either will or will not be able to go forward in front of an adjudicator. If you are, more of that in a moment. Anyway, go forward unless you've got senior level, very senior level management. The complaint has to be filed within 90 days of the dismissal. It's so easy to get caught up in the usual demand letter and negotiations that go on at the beginning and miss those 90 days. There's just about no flexibility on them. You need to BF right away as soon as the individual is in your office, 90 days from the date of dismissal, and make sure you get your complaint in. There's a generic form that's at the back of my paper that is used for all complaints under the Canada Labour Code, unjust dismissal and everything else. Very simple form to complete, just some basic information identifying the employee and employer, and then you simply indicate it's an unjust dismissal or a constructive dismissal if that's what it is, without particulars, file it, and you've got no more problems with the 90 days. As soon as the complaint has been filed, a labor affairs officer will be assigned to the file. Their practice, and really until very recently in Ottawa, these people really prided themselves in terms of the speed with which they were dealing with these matters. It's getting tougher now with cutbacks. But it's still their practice, they tell us, to, within a period of 90 days, attempt to effect a settlement, and if that isn't possible, move the file forward and look for an adjudicator to be appointed. With cutbacks, as I've said, that time limit isn't always met now. The other thing that I've found you have to watch with the labor affairs officers, like anything else, there are good ones, there are ones that aren't quite so good. Some of them can be very aggressive in terms of dealing with your client employee. Basically telling the employee, this is what you've got to take, there isn't anything in it for you to take it further forward. The same individuals typically are not always accommodating of the role of the lawyer in the process. And I've found over the years the best thing to do is to caution your client that they may run into this and to stay in touch with you, not to accept anything without touching base with you, but attempt to pull back a little bit and let the labor affairs officer do his or her thing. Most of the time they're very effective. It's just sometimes I have found, as I say, what I feel to be untoward pressure being brought to bear on a client who doesn't quite know what to do. If the thing isn't resolved within 90 days, then the employee can request that an adjudicator be appointed and the thing goes forward to adjudication. There's no prescribed form for this. It's usually done by letter. And the minister has some discretion about whether or not to appoint an adjudicator. I have never had one turned down, and I think that typically the discretion is exercised favorably to the employee. They're just, and even still, that strikes me to be the case. Then, once that happens, you will get a call. Well, you get probably a short letter from what used to be Labour Canada, now it's Human Resources Development Canada. I'm just beginning to get that into my head. Telling you who the adjudicator is. You'll get a phone call from the adjudicator. A date will be set that's mutually convenient, and you find yourself at a hearing that looks a lot like a labor arbitration hearing. Because this is a dismissal case, the reverse onus principle applies just as it would in a labor hearing, and the employer has to go first with its evidence justifying the dismissal. The employee then responds. There's a downside, I find, to this process, and that is that there isn't the usual mechanism for discovery, for exchange of documentation. You can find you've no entitlement to disclosure from the other side. You can find yourself surprised at the hearing, both in terms of documentation and witnesses. What I recommend and certainly my practice, is to approach the lawyer on the other side, if there is one, and attempt to get some agreement in terms of exchange of information, documentation, maybe even witness lists in advance. Most of the time you can get some good cooperation on that. It's certainly worth trying. I've had both experiences, cooperation and no cooperation. But if you can get a certain amount of disclosure, you'll be better prepared for your hearing, there's no question, and you'll have a more meaningful, probably a faster hearing. The powers of the adjudicator at the end of the hearing are much more comprehensive than you have in a civil court. There is, as I've said, the power to reinstate with or without compensation for the period that the employee has not been working. There's the power to pay compensation that is not just restricted to the value of salary and benefits. There's certainly power to award mental distress damages and to be more creative in terms of compensation if that's what the adjudicator thinks he or she has to do to make the employee whole. Basically, the code says the adjudicator can do anything that is equitable in order to remedy or counteract the consequences of the dismissal. You see orders to provide references. You see orders to amend the employee's record. You see orders covering losses such as the value of disability benefits, insurance proceeds in the case of an employee who is now deceased. I've seen all of these things in the context of Canada Labour Code complaints. Once the order is made, it can be filed in federal court and is enforceable just like any other order from that court. The Code and the Employment Standards Act both say that the statutory remedies are in addition to any civil remedies that an individual has. If time permits, I'll have a bit more to say about Rassinen and the issue estoppel cases. There's some of that in my paper. Some of the other speakers have already touched on it. Because of what has been developing since Rassinen, you can't assume that if things don't go well for you under the Code or under the Employment Standards Act, that you can start from zero again with a wrongful dismissal claim. Issue estoppel may well apply. And as I say, I'll try to say more about that if time permits. Legal costs. There are a number of Canada Labour Code decisions which confirm that among the powers of the adjudicator is the power to award costs, including in exceptional cases, solicitor-client costs. And I set out a number, I think 4 or 5 of them in my paper. This is another valuable thing to remember when dealing with claims under the Code and is different from the Employment Standards Act situation. Recently, a federal court judge reviewing an award of an adjudicator under the Code made a decision that certainly caused a ripple in our office. He said, and the case is referred to in my paper, that there wasn't a power to award costs, and overturned a decision to that effect by the adjudicator. Looking at the case, it's a case called Big Island Band and Big George. I'll talk about it on page 8. I think what must have bothered Justice Nadon in that case was that the complainant had been unsuccessful, but notwithstanding, because of the circumstances, costs had been awarded. And that was just too much for the court. Wasn't satisfied that there was a basis for the award. I don't think, in view of the other cases, that the Big Island case means you can't get costs from an adjudicator under the Code. And I wouldn't worry from the point of view of the complainant about that decision, although if I was acting for the employer, I might want to raise it. Reinstatement, the cases have said a number of things about when reinstatement will and will not be ordered. I list some of the factors at pages 8 and 9. Generally, there's no question that there's the power to order reinstatement, but it won't be routinely granted. And some of the indicators that dictate no reinstatement or tend to dictate no reinstatement are listed there. Basically, if there just isn't a position, if there's been a really serious breakdown in the relationship, the adjudicators tend to balk at reinstatement. I mention on page 9 a case that is unreported, a case that actually caught me in a funny way, called Gowdy and Export Development Corporation, 1988 decision, that was appealed to federal court, or rather there was an application for judicial review of that decision to federal court that was denied. I don't think a lot of people know about this one, but it can be a very effective tool in the hands of a complainant and his or her counsel. This was a decision of an old law school professor of mine, Joe Roach, who I always thought, and I have to say, I still wonder, knew more about landlord and tenant than I thought this stuff, but he did some interesting things in Gowdy. The employee in that case didn't want to be reinstated and said so very clearly to the adjudicator. I don't want to be reinstated, I don't want to go back. But Roach felt that that employee should be made whole. So what he did was he compensated her with all the value of her lost salary and benefits to the date of the decision. I think it was about 11 months in that case. And then started to run ordinary common law damages for wrongful dismissal. So ran the notice period after the date of the hearing, with the result that she had just about double. And the reason I got caught on this was this particular individual had initially retained me and said, you know, I think my case is worth 2 years. And I said, no, not worth 2 years. And you don't want to go back, not worth 2 years. It's, you know, maybe worth a year. No, I think it's worth more. She found a lawyer in Ottawa that agreed with her, and he got this. So I remember that one now and use it when I can to advantage. There are other provisions in the code dealing with wage recovery, same sort of thing you see in the Employment Standards Act. Again, you use the generic complaint form. They're discussed in the paper. I don't think time permits me to go into a lot more detail about those unless somebody wants me to in question. Before I leave the code, some other very basic stuff in decisions under the code. Constructive dismissal can be complained of. It doesn't have to be an outright dismissal. The cases have said progressive discipline must ordinarily be applied, and if the employer says, no, this is a very serious situation and I shouldn't have to apply it, the onus is on the employer to establish very serious misconduct. The adjudicators under the code have said dismissal's got to be the last resort. The objective is not to punish, it's to correct the conduct. If you can correct the conduct with something less, then that is the discipline that the adjudicator will substitute. For those of you that do any labor, it sounds a lot like labor arbitrations. I had an example of the kind of serious misconduct that justified immediate dismissal recently in a Canada Labour Code case involving Imperial Oil. That was heard in Halifax, where the first mate in charge of a night shift on the vessel showed up for work impaired. There were no incidents, but he was fired on the spot, and that dismissal was upheld despite a 10-year excellent record. But even under those circumstances, the adjudicator really struggled with it. There are something called mitigating factors and aggravating factors that these adjudicators go through when trying to determine the appropriate discipline. And I tell you where you can find those. I actually didn't reproduce them in the paper, but I'll tell you in a moment where you can find those. Employment, I know I'm pushing here. Employment Standards Act. There isn't this kind of unjust dismissal remedy in the Employment Standards Act, but there is, of course, the ability to chase termination and severance pay. The form that is used is at the back of my paper. It's a 4-page claim form, and again, is the same kind of form that is used for other kinds of complaints under the Employment Standards Act. Much like the Labor Canada procedure, or the Canada Labour Code procedure, instead of a Labour Affairs officer, you have an Employment Standards officer appointed and assigned to the file and doing the preliminary investigation and attempting to get the thing settled at an early stage. If the Employment Standard Officer concludes that money is owing, he or she issues a payment order against the employer. And that order will also include an obligation on the part of the employer to pay an additional amount equal to 10% of the value of the order, or at least $100, to cover admin costs. If the employer doesn't like the order, it can appeal. by applying for a review, and the paper talks about how to do that on page 12. But what's interesting is that the employer has to pay the amount of the order plus the 10% admin fee before the review can go forward. So it can be a really effective way to get an employee client some quick compensation. Often, not always, but often the employer at that point would just as soon pay the thing and be done with it. I had an experience in the last year involving an employee who laid a complaint for wages owing under the Employment Standards Act and at the same time was just bent on instituting a civil action, against our advice actually. We claimed some additional damages, but we told her that we felt the case wasn't strong on those and that she was better off with the Employment Standards Act procedure. But we did both, and all at the same time as the payment order was coming down from the Employment Standards Officer, we were still arguing about preliminary pleadings in the court action and not getting the thing resolved with on any sort of speedy basis. That case was going to roll ahead to trial because the employer was kicking up enough dust that it wouldn't be dealt with on any sort of preliminary motion, but the Employment Standards Officer wasn't having any trouble at all. So it sort of came through to me and to my client very clearly how much more effective and how much faster that procedure is. Another little pointer, we've had some luck in Ottawa, and I don't know whether it's just the nature of the Employment Standards Officers we're dealing with, but the admin fee will sometimes be left with the employee as a kind of compensation for costs. We've persuaded some Employment Standards Officers to do that in Ottawa. So you might give it a try. It may just be that we've been lucky and it'll all come crashing down soon, but we have had some good success with that. There is now the Wage Protection Program under the Employment Standards Act that gives people up to $5,000 worth of protection on not only on unpaid wages, but on termination and severance pay, and there's stuff about that. Have I missed something? Knocked all that out too?
$2,000, no termination pay, no severance pay.
I thought it was up on that
Useless.
stuff.
No.
So it's no good at all.
Bill 7
Okay.
changed all that. so
Thank you,
it's-
Barry. Thank you. Keeping me on my toes. I knew that it had knocked out some other stuff in the Employment Standards Act, but I didn't think it. There were some successor rights provisions, very difficult ones in the Employment Standards Act introduced by the last government, which are gone as well, so we won't talk about those either. Limitation period under the Employment Standards Act, basically 2 years. So not the 90 days you wrestle with under the code, but still something to watch. Issue estoppel, the cases are at pages 15, 16, 17 of the paper. Rassanen is the leading case in the area. Ontario Court of Appeal decision we've already talked a bit about. That one involved an employee who was held not to be entitled to Employment Standards Act termination pay because he had refused an offer of, quote, reasonable alternative work. And that employee was stopped from proceeding with his civil suit because that question had already been resolved against him. The cases that have followed the issue estoppel principles, recent one called Deborah. You can see this working again, where this time the plaintiff was trying to put a stop to a defense being advanced by his defendant employer justifying wrongful dismissal. I think the best thing that I can do is get you to take a look at Deborah. There's another case called Machado and Pratt on the next page. You can see examples of how these things can be effective tools, not only in terms of getting what you're entitled to under the Employment Standards Act, but also in terms of getting some nice findings of fact that you can move forward on in a civil context. One thing that I wanted to point out I've been talking again and again about the cases under the Canada Labour Code, how to find them. It's not easy. There used to be a service maintained by what was Labour Canada that kept track of these cases. That service is seriously out of date and isn't much help. There is no separate service, although the feds are talking about establishing one. The best thing you can do, apart from trying to keep your own, is use Quick Law to check the labor arbitration cases and the labor arbitration summaries. They pick up some of these decisions. Not a ton of them, but some of them.
There's Employment and Labor Law Digest.
Yes. Some of the newsletters,
carries.
some of the publications will pick them up. If you're on the mailing list for those, you can watch for them and basically pull them and copy them, keep files of this stuff, because they're hard to find when you're researching a particular situation. Now, in closing, I want to point out one other thing so that we're not all reinventing the wheel all the time. Both the Ministry of Labor and Human Resources Development Canada have excellent fact sheets, information booklets on the various procedures under the Employment Standards Act and under the Canada Labour Code. They're helpful to individuals trying to understand this stuff, and they're helpful to lawyers too. Easy to get. You just call the appropriate offices. I've got a complete set of them here. They tend to have, both outfits tend to have different fact sheets for each kind of claim. Anybody wants to take a look at these, just come and see me afterwards, and you can. And that's it.
Thank you. Any questions from the audience? Yes.
Yeah, the case you mentioned of Deborah, I happened to read recently. The troubling thing I found about it was that it was all based on the fact that Employment Standards officers' findings. We've got a referee's hearing after a fact-finding meeting, and the issue that, this whole issue that it was only an Employment Standards officer is not even addressed in the decision. And my reaction was, well, this isn't what RAS required. And I was just wondering, do you think that case from that point is going to survive? Now we have to worry about Employment Standards officer?
I think we really do. Yeah, I think we really do. Be interested if Barry takes a different view. But at the moment, I think we have to worry about Employment Standards officers, that's for sure. You're absolutely right. It was just an ESO's order after a fact-finding conference. He found there was insufficient evidence that the plaintiff had been terminated for cause, and the court said issue estoppel was clearly applicable as the same issue had been decided. The decision of the ESO was final. There had been no appeal or judicial review. The parties in the civil lawsuit were the same as the parties before the ESO on the fact-finding conference, and the court was happy that with that effort having been made, even though it isn't a hearing or a trial, it's a kind of a hearing, I guess, that the defendant employer was stopped from relying on any of the categories listed in the Employment Standards Act as support for cause for dismissal. So if the employer wanted to develop something else, it still could. But if it was basically pursuing the same sort of thing that had been pursued before the Employment Standards Officer, it could not go forward with that defense. I think we have to worry about it because I'm certainly finding in Ottawa, and I'm sure you must be finding the same thing here, that the courts are backlogged. They're looking for ways to deal with things quickly, and they're not happy with people pursuing things in two different forms.
If I was acting for the employer in that case, I would have had the judge take a view, and I would have taken him on a fact-finding. And if at the end of that fact-finding he found that that was at a judicial proceeding, I would have seriously questioned the competence of that judge. Fact findings are not judicial proceedings unless you count little animals with marsupials as being part of the courtroom process. They have no concept of natural justice. They are a disaster. Now, the one advantage of that Dubray case is that the next time an Employment Standards Officer refuses you an adjournment because you just happen to be pregnant, which I know happened in a case of a friend of mine, you can remind that officer that they're making a very important quasi-judicial type decision, and please read a basic 3-page text on administrative law. So it can be used to perhaps intimidate Employment Standards Officers into doing decent jobs, but I think it's a scary decision, and it'll just force more people to take it to adjudication. Another question here, Janice?
Yes, just a comment. I would say that powers of the Employment Standards Office, I do tons of fact finding. I'm a pregnant lawyer for these times. They are, at least some of the ones in Toronto, they are profoundly uncomfortable in their powers. They receive no training. How to
Yeah.
inform the officer and make the officer's job easier, given their uncomfortability. Role is, I would say, warranted.
Yeah, my experience with them in Ottawa has been more positive. The couple that I'm thinking of really has been more positive, but we've been taking these fact-finding sessions, if you like, pretty seriously even since before Deborah. And I mean, I agree with absolutely everything that you're saying. As far as I know, Deborah is the only one that applied Rasmussen to a decision of an employment standards officer. The other one, the Pratt and Whitney case on page 17, involved a decision of an officer that had been overturned by a referee. So it is unique, but I think until somebody does something different, we have to treat these things with real seriousness, prepare properly, and attempt to get a result that we can live with.
Or
Or
just-
don't do it.
No, or don't take the fact-finding seriously and put your resources into the appeal before the adjudicator. That's a real
Well, sure.
judicial
That's
proceeding.
right. You take an appeal, and that's what, you see, was troubling the court in Deborah. The parties hadn't bothered with that. They'd lived with the decision. What the court was basically saying is, don't ask us to revisit it. You have a remedy there. You have a route you can follow. Do it.
Okay, one last question from the side here.
Yes, on the same issue, what would you say about for the referee hearings under the Insurance Act, or also reinstatement hearings under the Workers' Compensation?
What we've been saying to ourselves in the office is that we have to worry, just as people did here earlier today, we have to worry that the same principles might apply. We haven't dealt with it yet. I haven't seen anybody else dealing with it yet. You know, you may be able to make a good case that the necessary elements of issue estoppel aren't made out in any particular situation. But when Rasmussen came down, and with the decisions that have followed since, we're taking all of that stuff seriously.
Yeah,
I think the potential is there.
Under UIC, a referee hearing is not adversarial. The employer doesn't show up.
Yeah,
So there's
which
no
would
way
make
it
a
could be
difference.
found to be against the employer. Under the workers' compensation hearing, Janice is shaking her head, but under the workers' compensation hearing, having done one of those, if you win, whoever loses at the reinstatement hearing level could knock it upstairs to WCAT. And much to my surprise, WCAT, although it's called an appeal tribunal, hears the case de novo again. They don't even take their own officers as something worthy of reviewing on a
they
judicial
don't.
basis. They redo it all.
And routinely disagree with them and their policies.
Yes,
Yeah.
yes, and take you through the whole thing again. So I think it raises issues as to whether a reinstatement officer, WCAT perhaps may well be, but again, there are different overlap issues.
What about a UI officer? In that, you've got a situation now where
Please
the
use.
guy was fired allegedly for cause, went to UI, I wrote him a letter, in fact, to take to the UI officer. Apparently, the company didn't object. They said, what the hell, give him his UI, we're still gonna allege cause. When I tried to bring this up to employer counsel, they said, well, we just decided not to object.
Yeah, we didn't want to do him out of his UI.
The UI's attitude is if the company doesn't object, then we'll give them his UI. Is that in any way an issue to stop?
Well, I think the employer can get involved in UI if it wants to.
If they're vicious
Yeah,
people.
they don't normally. The argument from the employee's point of view is going to be, well, it could have. They could have been the same parties. What I think might be quite helpful to the employer, though, on the unemployment insurance situation is that I suspect the tests and the standards are quite different in terms of qualifying for UI benefits than they are in terms of common law wrongful dismissal, just cause. I mean, even mitigation and.
Other than the employment standards, yes.
But I think key in UIC is the employer has no financial interest. He's not a true adversary. And so I have trouble understanding.
Shows up. What if the employer shows up at the USC hearing? Is it bad?
Then he
Probably
may-
better for the employer not to play
Yeah.
ball.
Yeah. Or
And
write a
just
letter,
pull.
or write a letter saying, although we maintain our position that he was terminated for just cause, we do not wish to devote the resources necessary to fight this, and therefore, so sort of set a stage for
Yeah.
why you've got better things to do than sit around in front of the referees arguing. Okay, Janice will be around anyway, so you can ask other questions. We have to move on to mediation. Thank you very much, Janice.